Welcome and thank you for standing by. All participants are on a listen-only mode until the question and answer session of today's conference. During that time, if you would like to ask a question, you may press star, then 1. Today's conference is being recorded. If you do have any objections, you may disconnect at this time. Now I would like to turn the call over to your host for today, Ms. Janice Wingo, International Trade Administration. Ma'am, you may begin.
Hey, welcome. Welcome to the second conference of the morning. This one we have He Jing back again. Lawyer He will be talking to us on rectifying enterprise names in China. Lawyer He will speak a little bit on the presentation, and then he'll be open to questions. He's also said that he is willing to receive email questions from people in the audience or people listening to the audio recording of this or a previous presentation. His email address is he.jing@zypartners.com. I'd like to tell you a little bit about Lawyer He. He is a JD from Notre Dame here in the United States, and he has his BA for Peking University. He spent many years working for a very large U.S. law firm in Beijing and in Hong Kong. He has incredible experience in IP matters, and we're really fortunate to be able to talk with him this morning.
Thank you, Janice. Okay, thank you everyone on the line for taking your time to be in this webinar. And today I want to take this opportunity to talk about how to deal with enterprise names. This is one of the I would say the tough areas in China in terms of IP enforcement. Whenever we talk about enterprise name problem in China, the first example I would like to use is actually the Starbucks. And you can see from this slide the two similar logos. The left one has the Chinese characters, which you probably cannot read, which is basically a logo made by a local Shanghai company. It's actually a coffee shop. The problem with this one is that they use the Chinese counterpart. The Chinese name of Starbucks is what's called Xinbake. Okay, they put this Xinbake, the counterpart of the Starbucks, in their enterprise name. So the point for this local infringer is that, hey, I put this Shanghai Xinbake on my logo. It's actually use my own trade name. It's just the usage of my own enterprise name. It's not a trademark infringement. This actually was a big case that happened a few years ago in Shanghai. Eventually, Starbucks sued this Shanghai company and won the court lawsuit in the court first instance and the second instance, and it's concluded in 2007. This case just to give you a sense or give you an example that what the American companies might have to deal with in China. The point is that they are, the Chinese infringer may not just use the English name or English name of your trademark, but they actually can steal the Chinese name of your trademark and put that into their enterprise name, and using that in a very misleading way to confuse the public. Now, how you can deal with this kind of a situation? What kind of remedies you may have in China? Basically, in China, there are two approaches that you can deal with the infringements of the enterprise name issue. The first one is to file administrative complaints to Administration for Industry and Commerce. This is what we normally call AIC. This is a very important Chinese government agency that deal with the IP issues and trademark counterfeiting and all kinds of other regulatory issues. This is what we normally call administrative enforcement. And many overseas companies are very attracted to the administrative enforcement because it's normally relatively fast. There are not too much formalities. But when it comes down to enterprise name enforcement, the situation could be quite different. I will tell you a little bit more about it in this presentation. The second way you can deal with enterprise name is to do litigation in the court. And the Chinese court are actually really stepping up the efforts to deal with the issue of enterprise name in recent years. The reason is not really because U.S. companies or European companies or Japanese companies suffered a lot in this kind of problem. It's more because a lot of the local Chinese companies are starting to see that their brand name, their trademarks, are counterfeited by others, and they see their trademarks become part of the enterprise name of other companies, which was used for really unfair practice in the market. So the courts really realized how serious the problem is. They're really stepping up and had made a number of decisions in favor of legitimate brand owners. Now, having said that, what are the two choices that a brand owner may have in China to enforce the trademarks against the improper or illegal enterprise name? I want to come back to the AIC approaches. On the surface, it looks very straightforward. Now, you can just go to the government authority to file a complaint and ask the local authority to deregister or amend the company name or enterprise name. But in practice, there are quite a couple of very important considerations. Under the current rules, the AIC are relatively responsive if you are a holder of a well-known trademark. You have to qualify as a well-known trademark, then you really have to show you have done quite a large business in China. You have done lots of promotion, spent a lot of money in the advertisement. You have a certain big size of sales and manufacturing in China, okay? And in practice, you really have to generate quite a bunch of paperwork to prove you're a well-known trademark. And in addition to this, you also have to show there are a strong likelihood of confusion. Sometimes in some AIC even ask you to show an actual likelihood of confusion. But the point is that if you are a well-known trademark, this may relatively easy for you, okay? And some brand owners, including the U.S. companies, their trademarks have been recognized as well-known trademarks in the past years because of court litigation or some other trademark applications. But if you are SMEs, or for some reason your trademark has not been recognized as a well-known trademark in China, you may have to really do a lot of work if you want to go through the AIC route. Now, what are the procedures? What are the procedures in terms of doing AIC enforcement? In fact, there's no national rules in this regard at this moment. It's very interesting that some local governments come up with their own rules how to deal with the enterprise name in China so far. For example, Shanghai governments have done a relatively very good job. They have laid out very good procedures. And in some instances, this might be good news for SMEs. In some instances, they even are willing to look in certain scenarios where a trademark or brand owner does not really have a well-known trademark in China at this moment, but when there's an actual likelihood, an actual proof of the confusion, they're actually willing to take down the enterprise name, which use the brand owner's trademark or some other logos. Now, when you look at the procedures, it starts by filing a complaint. You need to present your facts, present the evidence, and you need to provide certain forms to prove your corporate status. And there are normally two scenarios you need to show. Firstly, is that you need to tell the government authority whether the infringer really using your trademark, your mark, your key mark in a prominent way in the enterprise name. This is very typical in China. Okay, some infringers. They have their own enterprise name. Let's say, for example, let's come back using the Starbucks as example. Let's say they use the Shanghai Xinbake, which is a counterpart of Starbucks. The enterprise name is Shanghai Xinbake Company Limited, but the infringer may using the enlarged font for this Xinbake, on print that on packaging materials on the coffee jars. If they do that, we call this as a prominent use. If you find this kind of evidence, someone using your mark in the enterprise name in a very exaggerated way, in a prominent way, in large fonts, and the AIC may find that, hey, that's trademark infringement. If the infringer simply just print the enterprise name in a normal font, on the packaging materials, on the signage, well, there will be no trademark infringement, unfortunately. But the AIC may say, hey, there is an unfair competition if there's really likelihood of confusion. Another thing you need to show in the complaint that you need to prove with some evidence that the way the infringer uses can really cause a misleading effect, mislead as to the source of the goods. Or otherwise, you can argue that the way the infringer use your mark in the signage or in the enterprise name really infringes your legitimate other interests. In terms of timing, normally defendant has 1 month to respond. And there may be a hearing. It's going to be a short one, maybe half a day. And what is really interesting is that the AIC normally will do mediation. And this is sort of like a culture of the Chinese government enforcement authorities. They rather you to settle the case quickly instead of they go through the whole procedure and make a decision for you. So there are many cases that we see. There are some cases we see that both sides actually made a settlement out of this mediation proceeding. Normally, when this happens, it's normally because the infringer realized the other sides indeed have a well-known trademark, and they will face a very unfavorable decision if they cannot settle. The whole decision normally is going to be made within 60 days. Now, the next part I want to talk about what happened after the decision is made by the local authorities. Let's assume that if you have a good decision by the local government officials, it's not totally a complete story yet. You have to really push the local AIC, the local authority, to pressurize the other side to apply to change the name, because you cannot go to the company registrar just to change the name for them, nor the AIC could do that themselves. The infringer has to do it. In practice, the AIC has actually has been trying to using the threatening to impose a fine or the refuse to allow the company to pass the annual inspection if the infringer fails to comply. So that's the part I want to talk about in terms of the AIC enforcement. So if you are SMEs and if you don't have a well-known trademark, if you still want to go through the administrative enforcement, my advice would be you should really find your way to use your really reliable counsel to really communicate sufficiently to the local government authority before you file the case and get the feedback what is the likelihood of success. Next part, I want to actually talk about the Chinese court. What could you do through litigation to deal with enterprise name where you find your trademark or your logo are counterfeited? In fact, as I mentioned before, the Chinese court have been doing a very impressive job in this regard. A recent case is that the Abbott, the American company Abbott Lab, has done 4 cases in China where they're going after the infringers who uses the Abbott's Chinese name in the company name for the same kind of product, the dairy product. They go after each of those infringers in different cities, and all the courts gave a very favorable decision to Abbott. In terms of a legal test, in terms of legal grounds, and normally a plaintiff must prove that he got a trademark registered in China, and this trademark has been counterfeited by infringers in the enterprise name. Of course, if your trademark is already well-known, recognized by Chinese court or by the Chinese trademark office before, that will significantly increase the chance of your success. It's a little bit similar to what I said in the AIC approach. if the infringer is using your trademark in a large font in another prominent manner, that would be trademark infringement. If they don't, if they simply print your mark as part of a company name, and the court may find it as an unfair competition act. Assuming that you won a case in the Chinese court, but the story still does not end, and you still have to really closely follow up with the court judges and asking the judge to really issue a specific order, and to compel the infringer to change the names. And ultimately, the name will be changed as a part of the AIC. The last part, I want to come back just to offer some of our practical observations and considerations that you may consider before you proceed with this kind of case. And as I said before, the AIC approach could be very fast, but may not be as easy as it appears. So you really have to review your own situation and actually communicate to the AIC officials and decide whether it's really the preferred way. And the court litigation so far has really produced faster results. And in China, the IP litigations can be concluded in 9 to 12 months at the court of first instance. What's really encouraging so far is that we have seen in a few cases where the Chinese court are offering relatively large amount of damages for the plaintiff, especially when plaintiff is foreign companies. And that amount may not be as significant as the one you normally see in the U.S. court, but the amount of money may be sufficient to cover your legal fees and investigation fees. And for example, in the recent Abbott cases, we saw the Shanghai court awarded 500,000 RMB to Abbott, which is equivalent to $75,000 US. And if you go through litigations, we normally recommend to file two claims. One is a trademark infringement, and the other one is unfair competition. So it gives you a kind of a guarantee to win the case at the end. And one thing very important is that you cannot assume you got to find a victory after the court give you a favorable decision. You really have to go down the chain to really work closely with the local company registrar, the local AIC, to force infringer to change the name or completely de-register the name. That's what I want to say about the enterprise name enforcement. Any questions?
Thank you. At this time, if you would like to ask a question from the phone, please press *1. Please unmute your phone and record your first and last name clearly when prompted. To withdraw the request, you may press *2. Again, if you would like to ask a question, please press *1. One moment, please.
In case anybody's listening to the audio recording and they have any questions for Lawyer Hub, he can be reached at he.jing@zypartners.com.
Once again, if you would like to ask a question, please press *1. At this time, there are no questions from the phone.
Lawyer Hub, can I ask you a question about working with the AIC to have a court order imposed?
Sure.
Give us an example of the kind. I know that it's very important to have a lawyer who's quite knowledgeable. What kind of service does the lawyer do to help to make sure that a court's order is imposed?
The counsel really need to help to set an informal way. Okay, you have to give a decision, a copy of a decision to the AIC because the court decision really made in the civil court, and it's really up to the plaintiff itself to bring the copy of the decisions to the local AIC officials, and the file normally could file separate petition to the local AIC to ask the local AIC to order the defendant to change the name. Okay, and if the other side failed to take any action, the council has to lobby the local AIC again to go through the official rules and to impose a fine, or simply ask the AIC to notify the other side if the infringer fails to change the company name, they will really suffer from the legal consequences, which includes that fail to renew their business license the next year. And what we found really impressive is that the Shanghai AIC has laid out a very clear procedure rules in this regard. They clearly stipulate that when the court order is made, and if the other side fail to show up to change the enterprise name, and then they will refuse to make any changes, future changes for this company in the future, and they will not give official permission to in the annual examination of business license at the end of the year. But in some other cities, we have not seen this kind of clear rules. So it's really up to the council to lobby the local AIC in other cities and they really educate them, what will be the right procedures to deal with this kind of problems. Now, in our experience, and in this area, as I said, it's relatively difficult area because the AIC rules have not been that clear. There are inconsistent practice in this country. So the reliable council has really to demonstrate to the local government authorities with the credibility that what will be the best practice for the local AIC officials to follow.
Thank you.
At this time, there are no questions from the phone.
Well, we're coming up to the top of the hour, and I want to thank Lawyer He again, He Jing, for making the two presentations on rectifying enterprise names, the one that's recorded just now, and a previous presentation on .cn domain names. I also want to remind you that we have a webinar on Tuesday where we'll have another China-admitted lawyer talking about landlord liability cases. So that's Tuesday at 10 a.m. Eastern Time. We'll have a different dial-in. You can also look at recordings of these presentations at the stopfakes.gov website. Lawyer He, thank you again for your time, both of these presentations.
A pleasure. Thank you.
Thank you for participating in today's conference. You may disconnect at this time.